Election Service Board will come to order on October 10th, 2018. And we have the agenda. We read the notice of meeting first.
Yes, sir, I will. Thank you, Chairman. Notice of October 10th, 2018 meeting of the Collection Service Board meeting was posted to the Collection Service Board website on October 2nd, 2018.
Agenda, are there any corrections or additions to the agenda? If not, they'll stand. Do we need a motion?
Yes, sir, that'd be great.
So moved.
Second.
All in favor say aye.
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 August minutes, did we all get copies of those? Are there any corrections or additions to those minutes? If not, we'll entertain a motion to approve the minutes from the August meeting.
So moved.
Second.
All in favor say aye.
Aye.
Director's report.
We'll jump right in then to the budget. Since our last meeting, we had a couple more months added to that, so I just wanted to kind of give you one big snapshot with the fiscal year prior, and then of course we're jumping into the next year. We're in this current fiscal year. If you notice there from February, we talked about it last meeting. But a lot less red in the net deficit. So we really plugged that hole with the things that we did administratively to deal with the legal report and to really narrow some of those handling those complaints through SOP. By not referring those that aren't inside the jurisdiction, handling the anonymous complaints where there was no information. We did that earlier in the year. That seemed to help out as well. And then, of course, working now today, we'll discuss that later, but the agreed citation schedule as well. That's the last prong of all of that, bringing that together. And as a result, too, it assists with overall admin costs, too, because the administrative cost backs are it's all basically number of complaints and number of licensees. It's basically an overall budget that's assessed to that as well. Whereas if we're handling a lot of those things administratively, we get some relief there as well. So without having to tie in extra resources. So it seems like we're going in the right direction. Just to give you the numbers for this fiscal year, it looks like the revenue coming in, total revenue is $28,000. And then the expenses, $15,000, leaving us in a net surplus of $13,000. And so we look good. We're moving in the right direction. And of course, we always monitor that. That's the reason we do it month by month, so we get the trend analysis. So in case there's ever a dip, or we can move resources and address that immediately instead of waiting on a quarterly type of a report and then getting surprised. So if there's any questions on that or comments.
We've done administratively to reduce expenses. Are those expenses that the state would have anyway, only they're just not being billed to us, or does the state lay off?
Administrative cost backs are basically the total expenses for all of our programs. And then, obviously, Collections Board wouldn't, out of, let's say, 22 programs, you wouldn't give them an equal part because they're a smaller program, maybe have less complaints than, let's say, Cosmo and Barber, who has 60,000 plus licensees, and they have a mini committee board meeting just for complaints. So there's a lot of complaints. So to work that out, the fair way to do that, to take all of the rent and the phone lines, fax lines, office type expenses, payroll, those type of things. That's not already a line item, in Edison. Anything that's specific to the department, that's budgeted to the department, comes out of Edison. But then the general stuff that we all share, like we do share some common space with other boards. So they give you a budget plan based on the number of complaints and administrative kind of total, what your footprint is as an individual board. They take a snapshot, a number of licensees, complaints, that sort of thing, and then give you and of course make that adjustment each fiscal year as well, or quarter. They'll look at that, and if it looks like you take a big dip in complaints and in licensees, then they'll recredit that to your account. If they already had, if a budget plan was set to remove so much quarterly, but it looked like you've dipped below your projected total, then they'll recredit that. I've seen that with a couple of our other boards. Court reporters in particular was one of those that I saw that where they had to credit administrative cost backs.
Managers used to consider, we used to have the managers have a separate license. Was that considered licensees for us, so we took a big dip in licensees? That we
Collection service manager.
service manager also be licensed.
I don't think that was a significant dip.
But did that add to the number of licenses we had?
It would have, yes.
So that cut our licenses in
That
half.
would have.
Because everybody had to have one, as
Right.
well as the agency.
Right,
So-
that's all a part. License types, they do consider that, not just licenses, but the license types. So that went into that overall consideration as well. Yes, sir.
Saved us a bunch getting
It
rid
did.
of them. Yeah,
Mhm.
good.
All right. If there's unless there's any other questions, that doesn't require any sort of administrative action from us. That's really just, or formal action from us. That's just informational. But I do want to talk and revisit application reviews. If you remember a couple months ago, we discussed that the only thing that we would bring to the board would be basically anything that the pending litigation that had moral turpitude or that has pending litigation in Tennessee. Those were the two prongs that we were going to bring those application reviews to you. We had one application that came in recently that fit into that, but something that we didn't address, so I'd really just like to get the board's position on it. We had one that they disclosed their pending litigation, but it was in Western District Tennessee Court. It's a federal case, but it was sealed. So they only had one case that was pending in Tennessee, but there's no information forthcoming, so there's nothing we can bring to the board for their review.
We need some help with the iPad up
sure.
here. Oh, there you go.
Oh,
This was the case for the licenses? I mean, for the
Wait,
licensing.
No, come back.
yeah, this thing is not tricky. Right there.
Yeah. All right.
Go ahead, Steve, you were saying?
It's sealed in a federal court. Was it against the agency or against the one of the owners, or know from that what the suit was, the litigation was?
I don't know that there's any particulars. It said it was unable to generate a docket report. Carol, do you know if there was any particulars that you're aware of?
Thank you. Yes, when it's filed under seal like that in federal court, we can get a caption, which pretty sure the applicant was the defendant in that matter. I'd have to look at the chart. But there were no details available. They publish a docket report, which shows all of the pleadings that have been filed. And in that one, it was sealed. Now, why it was sealed, I don't know. Not able to get a cause of action as far as what the allegations were when it's sealed, because I couldn't see the.
It's not right to make an assumption, but why would you seal something if it didn't have some degree of moral turpitude?
Well, I mean, I know in some cases, like family, and I'm going to let the attorneys weigh in, a lot of times if it's like got a lot of sensitive information in it regarding Social Security numbers and things filed under seal because they don't want the public to be able to access it.
Fair enough.
So it's not necessary, I mean, it could be, but
But we have no definitive way of knowing that because it is a sealed record.
Will it stay sealed? Eventually, will they open it, or?
Doubtful. I have found in my practice that most of the time it's not a case of moral turpitude that a case gets sealed. It's exactly what she was talking about, which is personal information, that doesn't need to be available to the public. And we could file a motion. We could intervene and file a motion, I guess, if we wanted to, but that seems extreme to me.
What about redacting that personal information and then unsealing it? Would that be a,
The only way you can get it unsealed is if the federal judge allows it, and we'd have to petition the court to do that.
not that important?
So in those cases, just some guidance from the board is what we're after, because we didn't really foresee, or when I say we, I didn't foresee that we would be running into any sealed cases, where we couldn't get any information on. So in those cases, how would you like us proceed? Or in particular, just with this case, so we can resolve this application, because their financials are okay. This was the only issue, and I brought it to the board on their instruction.
We can ask them,
Ask the individual,
yeah.
can you tell us what the case is about? That's not a bad idea.
Yeah.
We're not looking for the details, just tell us why the case was filed.
Do you have any comments in regards to that? Because I know you've been corresponding with them.
I don't have any further information in regards to the case I can ask, because he's been asking about, what's next since we're reviewing the litigation.
Asking them, and if they're going to lie, that's a whole problem anyway. They probably.
I could bring that to, I'll just give you the next announcement as well. We don't have any formal board business except for what may be added to today. So we do have some cases to take care of at the next board meeting. So we're going to teleconference at the December 12th meeting. We could just add this to it, and I could give you an update on the information that he provided.
If it's not, they've applied for the license and they want to get started, I'd assume. They don't want to wait another couple of months. So if it's not if they answer the question and it's a reasonable reason, like personal or estate or something, then just go ahead and approve it as far as I'm concerned. But
I agree.
if it has something to do that we should consider, if it's like,
If after he responds, if it's something that falls into moral turpitude, then we bring that. Otherwise, we'll just approve it.
yeah.
Yes.
Okay.
I'm good with that.
Yeah, there's no reason to hold him up until we meet in December.
Okay, that's fine then. We'll do so then.
We need a motion for that?
Yeah, let's do that. Since that detail wasn't really worked out last time when we made a motion in regards to the two prongs. So if someone would make a motion in that regard, that'd be helpful.
What's the name of the case?
Well, just
I move that based on the case that you've identified, we reach out to the individual and ask them what the basis of the case is. If the basis of the case and their answer sounds reasonable and it's not moral turpitude, then you all just go ahead and approve it.
I'll just identify this case too. They did give an identifier 416-CV-000-33. That's the case number. All right.
And in your administrative view, if it's should be brought to the board, then we'll take it to the next meeting.
Second.
This motion been made and seconded. All in favor, say aye.
Aye.
That's all I had as far as administrative items. So unless there's something else that needs to be addressed administratively, we can move on to the legal part of the agenda, if that's okay with the board.
I'm ready for that.
I'll just start out by reading
I'm sorry, go ahead.
I was going to say, I'll start by reading the case numbers in, then as we reach one where there's a need for discussion, we'll just stop there. 2018-03-2701, 2018-03-3361, 2018-03-3821, 2018-03-4531, 2018-03-6901.
I had a question about that one, and I wrote these down just so give me just a moment to review my. Did this respondent pay his 2016 consent order agreement?
I do not know. We would go into core and check on that, but yeah, not that. The fact that it's on the report in that way doesn't necessarily mean that it was paid or not. So,
Well, I think last meeting we had some discussion about about these consent orders, whether or not they were signing the consent orders and sending in their money, or whether they weren't and just ignored that particular one had been paid. Okay?
2018-03-1131, 2018-03-1701, 2018-03-5061, 2018-03-6001, 2018-03-9981, 2018-03-5711, 2018-03-3401, 2018-04-2691, 2018-03-9761, 2018-03-8841, 2018-03-4741, 2018-04-2811, 2018-04-2851, 2018-04-0891, 2018-03-9941, 2018-04-7771, 2018-04-5811, 2018-04-7341, 2018-04-1051, 2018-04-4671, 2018-04-4891, 2018-03-9181, 2018-009181, 2016-04-3131.
Let's go back. Steve, do you have any questions about any of them?
Yes, I have.
Angela?
6. The person who's making the call, is it the payday loan company or is it another entity collecting on their behalf?
Another entity collecting on their behalf.
On number 15, is a debt purchaser attempting to collect a debt, or is this a bank?
This was either the bank or the dealership itself that was identified as the respondent.
So the loan was sold, and if it was sold to a debt collector who wasn't attempting to collect on them on behalf, it shouldn't be a problem because they don't have to be. But if it was sold to a bank, somehow we don't seem to have requirement that banks, even though they collect on their own behalf, have to get a license. I mean, they're magically like attorneys somehow. I never have understood that. If a bank buys debt and attempts to collect on its own behalf, why shouldn't it be licensed?
Exactly.
That's always bugged me, because as a debt collector, if I attempt to make a purchase, call a debtor, then I have to be licensed. And I know the bank doesn't outsource it. So that's, I know the answer is going to be, well, that's the way it is.
Because it's a bank.
I really would like to know why banks are exempt when they buy debt and call on their behalf, because they buy debt all the time. You buy another bank, you buy its debt.
Right.
They buy assets, not the entity, so they're buying the debt.
What do you?
It's always driven me crazy.
It doesn't drive me crazy, but it is unusual. I don't understand it.
Could be an effective bank lobbyist.
Well, is it written somewhere?
Yeah.
I mean,
Well, I mean, there are certain exemptions, like, collection service is not included in the definition. Well, if someone's attempting to, and this actually came up in one of the cases that we just read into the report, where that the collection of guarantees or notes are not under the definition of
yeah, that was
collection
pretty
service.
interesting.
Yeah.
Yeah, I wondered about that.
2014 amendment. I looked up some of the legislative history on it because I didn't think it existed, but it turns out that it does.
The debt buyer could try to collect on a guarantee
Or a note, right,
or a note.
and be out of state, or be unlicensed in the state. It's
But the guarantor, the cosigner, cannot be collected from? Or, I mean, don't have to have a license to collect from a cosigner?
Cosigner is different than a guarantor, isn't it?
right. I guess there could be a situation where it could be the same, but if it were just purely, and like in this instance, it was an entity like an LLC or a corporation that the other party said, well, we'll do business, but we want someone to guarantee this lease. It was an ATM machine lease is what it was. And so they wanted to make sure that in the event that the entity folded up, filed for bankruptcy or whatnot, that they'd have someone to personally go after. In this case, they attempted to go after someone who wound up to be deceased already. Initially, when we looked at it, we believed that it was sort of a standard, well, you're out of state, you don't have a license, out because it was a guarantee that they were pursuing or exception carved out. So
And a note, any type of note? Because
any type of note, I don't know.
that covers a lot. of
Covers a
territory.
lot.
I mean, is a credit card a note? Because you signed for the application and you signed to borrow on the credit card with a credit limit. A line of credit's a note. That really gets stretchy. But we digress. I really would like to know. I think there might be a carve-out for banks somewhere, kind of like the guarantee thing, but it's always irritated me that they can get away with it. So I was just wondering if this was a bank, and is a bank. There's not much we can do about it.
That's a 2014 change in the statute?
Right. As to the definition of collection service, not including the collection of notes and guarantees. Right.
Wow.
You don't know if it's a debt buyer, and if it is, and they're attempting to collect it, then it's a problem. Bank, and they're attempting to collect it. I don't know. I'm not asking for any action. I'm just
Right.
curious if it's a bank, that's all. Okay.
Seven three four one, number 23. Are they allowed to report a collection before the 30-day validation notice expires? Yeah. It seems to me that the debtor should have 30 days, because of his validation notice, should have 30 days before any collection activity begins, which would include the notification to the credit bureau. And that's a question I don't know the answer to necessarily.
It doesn't make any difference.
When I was running my agency, I never reported anything to the credit bureau until after the 30-day validation had run its gamut.
DCPA, but attempting to collect the debt within the validation period.
Well, it was just it's the Fair Credit Reporting Act doesn't say that it can't be reported. I'm just wondering about the collection service, or the Fair Credit Fair Debt Collection Practices Act. Would that prohibit a debt to appear on your credit report before you've had an opportunity to dispute the validity of the debt?
And I focused primarily on, I remember this complaint because there was quite a bit of chronology I had to sort of sort out. So I focused on the FCRA piece of it. As to the Fair Debt Collections Practices part of it,
I don't know that the Fair Debt Collection Practices Act speaks to it specifically either. That's what I was just looking at. It does say, if the customer notifies within that 30 days, so I think maybe that could be seen as a trigger to stop from reporting before the 30 days, but it doesn't say specifically.
Right.
Number 27, I don't think 250 is enough for somebody not responding to us. If they don't respond to us, that's a huge no-no. That's not a slap on the wrist. That's a wake up. Go for 750 or some higher number. What do you think?
500 seems reasonable, and usually these things come back next time. Well, he responded, or he didn't get the message, and
Let's get their attention.
Yeah.
Raise it to 500. I just put a big question mark next to number 30, the new information on it, with the recommendation to close.
But it appears that cosigners don't have rights there.
Other one.
we were talking about earlier, right?
Yeah. So out of state, they weren't attempting to collect a debt. They were getting a note or a guarantee. Huh. All righty. That's all I had.
If there's no other than the one correction or the one addition that we made on the amount of the fine, I think it was 27. Are there any other? I'd entertain a motion that we approve the legal report.
So moved with that one exception.
Second.
Motion's been made and seconded. All in favor say aye.
Aye.
Okay.
It looks like we moved past the legal report into legislative updates then.
And we don't actually have any updates on legislation to report at this time.
Good.
All right, well, that was real easy then. We'll move on to Rule 0320-05-015. And
So, I believe Glenn sent out to the board the change in the rule that we discussed at the August meeting. I believe Glenn sent out to the board the change that we discussed in the August meeting, where I just eliminated the sentence, the term includes any debt, whether defaulted or not, from Rule 0320-055-.01 subpart 5, the definition of debt. So if the board is okay with that change, I'll actually need a roll call vote so that I can get the rules project started.
And would you read the roll, please?
yes, sir. Bart Howard? Well, I guess first we need a motion to that regard, and then we'll do a roll call vote.
So moved.
Thank you, Ms. Hoover. Do we have a second?
Second.
Thank you, Mr. Harb.
All in favor say aye.
Aye.
Let me do a roll call vote then in that regard.
Yes.
Ms. Hoover?
Yes.
Mr. Howard?
Yes.
Mr. Harb?
Yes.
Of course, Mr. Hellman and Mr. Holman are absent.
Thank you so much. We'll go ahead and get that rules project started to get that change, just to clarify for the public the definition of debt, because I know that sentence caused some confusion.
Brings us to our last piece, agreed citation schedule. As you know, we've been kind of tweaking this for a little while, trying to figure out how we can handle and expedite any sort of these claims that typically we would be comfortable with a certain round number and to provide some sort of consistency as well. So if you go to really, I think, probably page 2 is really where a lot of the effort was being made.
Yeah, we got it.
I got it for him. Here it
Thank you.
But if you, and then of course I'll let council really express and kind of expound on it. But the couple things we removed unlicensed activity. That was one that we didn't want on the agreed citation schedule. You want to get those each time, so those will continue to come to the board. And then we also, the first offense was a letter of warning, but that now has a fine. And then of course made the adjustments with the violations appropriately from the recommendations of the board from the last meeting as well. So that's what you see before you there. And of course, as council, if you'd like to expound on anything.
Yeah, I think the only other thing that we removed was the violation for the fraud and misleading practices. We removed that from the citation schedule, and as Glenn explained, we did increase the fine for a first offense as well as a second, and then on the third offense, if they violate any of these things in the third offense, those would automatically be referred to legal. That would then come to the board for this.
If they've done things had offenses other than these 4, would that count as a first or second offense? So they might have 2 things other than this and then do one of these. Does that go to legal?
So the violation that is not on this list would come to you on a first offense every time. If they're on this list, we would send out the citation. If they
kind of wasn't my question. I didn't phrase it well. I apologize. Let's say they've come to us twice and then they do something on this list.
That would be a first offense.
That would be a first offense against the list.
Yes.
But they've already had 2 other offenses.
Mm-hmm.
Why wouldn't that make it a third offense to the agency? Is it?
Because it's not a part of the citation schedule, those prior 2 offenses. So in order to effectuate it in the way that it sounds like you're explaining, and please correct me if I'm wrong, this citation schedule would only work for companies that have no violations.
Correct.
If that is the board's desire, I think it'll be a little bit more difficult to implement this citation schedule. But if that is what
I assume you can easily tell if they've had prior citations when you look at them.
Yes.
It seems like if they've had 2 other citations and then they have one on this list, that's a third. I don't know.
It wouldn't be a citation. The prior 2 offenses would not be citations. Those would be complaint violations.
Okay, but they're offenses that we may have reviewed.
Mm-hmm.
So if a company's had 2 offenses and they do a third that's on the schedule, that company's had 3 offenses.
Okay.
So do they get to go to the site? So in other words, they could have as many as 4 offenses before they actually come back to the board. Or 6 or 7.
So that would have been the intent, and that's why I'm saying if the board would only like for the agreed citation schedule to be applied to companies with no violations, that is a way to implement it. I think that's more of an implementation question rather than if the violations are appropriate.
I feel like that would be, but that this would be fine for companies without any citations previously or without any board action.
Okay.
Yeah, but if they've been brought to us for something and they're doing this, we probably ought to look at it with knowing that they've had other violations.
Right.
What do you think?
I feel like just generally we're a little more punitive than they are. And I would like for that to, I would like for us to get on the same page on these things. So I think that's the only way we can really do it, is say that these will be for the people that are
Right.
no violations.
Just as an overall thing, I believe Glenn and I brought this to the board in response to kind of some budgetary concerns. So if it's something that the board still wants to see all of the complaints, you don't have to adopt the
no.
agreed citation.
We don't want to see them all.
No.
But we want to send a message to people that are violating the rules. And also, it's not fair to the people that do it right. So,
To your point, too, since it's a great transition, so it works out great. Thanks for the segue. We were talking about the citation orders in particular last meeting, and we wanted that two parts. We wanted the cease and desist language, but we also wanted the voluntary suspension of the license with non-payment within 30 days, and that was to be effective immediately based on the direction of the board. That since has been instituted, and I've got a closed citation order that went out as well, and it had that language in there. And I'll just read the number 8. It says, and it's emboldened too. It's the last thing they'll read before they sign it. It says, following its agreement to the foregoing terms, everything that's named prior to the penalty, the cease and desist, all that sort of thing. If the respondent fails to pay the aforementioned civil penalty, the respondent agrees to a voluntary suspension of his Tennessee Collection Services license, and that's to provide that extra set of teeth, and then of course it's more punitive if there's another violation, because then it's unlicensed activity at that point.
I think I'm fine with it as long as these are first-time offenders.
Yeah.
If they've been guilty of other things other than these, then we want to see them too.
Yeah, since that's an administrative implementation on our piece, on our part, it's something that we're just really a matter of process. We'll make note of that. It's on the record. So in that regard, and then going forward with that direction, is this something that you would want to, do you want to see going forward? If so, we'll just need a motion in that regard and then move to adopt that.
yes. I make the motion.
I second.
All in favor, say aye.
Aye.
That's all we had on our end of the bench, unless somebody else had something they want to add for new business.
When's the Christmas party?
That's what I was going to ask you.
I mean,
Surely.
Well, other than that then, if, since we'll just take a motion to adjourn then.
move that we adjourn.
Second.
Motion's been made and moved that we, and seconded that we adjourn. All in favor?
Aye.
Adjourn, thank you.
That was sweet.
Thank you.
Thank you.